Notice, only substantive law is of force and effect. Affiant has no record or evidence that affiant is not sovereign, being, literally above codes, statutes, and regulation, yielding only to true substantive law if affiant has harmed any living man, as per directive/definitions of substantive being separate from procedural and administrative below. Statutes are a mixture of regulations, administrative, procedural, and substantive. Only the substantive has force and effect, and you'll rarely find those, but, when you do, they will not have sources in brackets, as those refer to administrative or procedural regs, but, will be sourced in parenthesis. It makes sense to allow a just venue, e.g., a suit in Washington should be set in New York if all the witnesses are there. It would be a hardship if 50 witnesses had to cross the continent. Substantive 1. Substantial, considerable. 2. Independent in existence or function, not subordinate. 3. Not imaginary, actual, real. 4. Of or relating to the essence or substance, essential, substantive information. Having a solid basis, firm. Procedural, of or concerning procedure, especially of a court of law or parliamentary body. Administrative, Admiral 1. Management, especially of business affairs. 2. The activity of a sovereign state in the exercise of its powers or duties. 3. Administration. Those who constitute the executive branch of a government. 4. Management of an institution, public or private. The term of office of an executive officer or a body. 6. Law. Management and disposal of a trust or an estate. 7. The dispensing, applying, or tendering of something, such as an oath, a sacrament, or medicine. Materia. In the civil law. Materials, as distinguished from species, or the form given by labor and skill. Dig. 41, 1, 7, 7-12, Fleta, lib. 3, c. 2, sec. 14. In English law. Matter, substance, subject matter. 3 BL. Com. 322. So, substance, material, is distinguished from species, or the form given by labor and skill. The labor and skill of the American man, being the species and form with which all property was pledged, constitutes at least one half of the term called credit. A creditor is not a debtor. Species. When spoken of a contract, the expression performance in specie means strictly, or according to the exact terms. As applied to things, it signifies individuality or identity. Thus, on a bequest of a specific picture, the legatee would be said to be entitled to the delivery of the picture in specie, i.e., of the very thing. Whether a thing is due in henere or in specie depends, in each case, on the will of the transacting parties. Brown.